Sandra Gullett, I think it is. I hope I'm pronouncing that correctly, versus Jason Gullett. Counsel, do you want to reserve any time?
Yes, Your Honor. I would ask to reserve 7 minutes. I'm William Townsend, here for the...
Hang on just a minute. Let me... Okay, you can begin, sir.
William Townsend, here for the appellant, Sandra Gullett. This case is about one issue. It's about whether or not there was a marriage. We have, and I think it's pretty well set out for you in the briefs and in the order of the judgment that was entered by the lower court in this. We have an unusual situation from my standpoint, in that the facts are all found as we urge them to the lower court, with the single exception that he found a state of mind of belief in a point of law in my client that you had to have a license under 741.08, that you had to have a marriage license before.
Was the crux of the lower court's decision, its finding that the two parties knew about the license requirement but attempted to skirt the requirement in having the ceremony first and then running down in the courthouse and getting the license afterwards, and that they knew it, and they needed the license first, but then just attempted to skirt that requirement and go through with the ceremony anyway? And is that a distinguishing feature from some of the other cases that seem to say, well, substantial compliance occurred because they didn't really know, or they were told by a clerk that they didn't need the license first, and that they could do the ceremony first and then get the license later?
The judge seemed to be very much, I don't want to use the word hung up, but very much concerned on the idea that in the Shelton case, which you're referring to, that in that case, a deputy clerk, that's the only case we have in Florida. We've put in cases from other jurisdictions, but that's the only case in Florida where you have an absolute case of an invalid license, and where the court in that case relies on, you have an invalid license for 3 days, or from Friday to Monday, and you have, he relies, the judge in our case said, bingo, they were told by a court, and in this case, they weren't told by a court.
Well, was there...
I'm sorry, I said court, by a clerk.
Was there I don't know, maybe I'm wrong. You correct me if I'm wrong. I thought that the gist of it was that the trial court, came to the conclusion that they knew about the license requirement and attempted to skirt it by saying, well, we'll just go through the ceremony first and then we'll go down and get the license later.
But
if that's the case, and then they intentionally attempted to get around the statute that way, why wouldn't that be a primary feature that would say, well, there's no substantial compliance here, as opposed to a party that does it by mistake? Because
the judge also finds that they both believed they were married when they left the River House. Mm-hmm. If you've read the briefs, you've had this. The judge makes a finding of fact, and of course we're before you. We took the unusual step of, since the judge had found all the facts our way, including the fact that that the opposing side was not credible in their testimony, and we went with simply the testimony of my client and limited the record from the transcript to that point. Because it isn't necessary as a matter of law from a de novo ruling, de novo approach that you're going to take to this, to the 2 points that are relevant. You're going to decide whether, as a matter of law, the belief of a person in a point of law, and it's a point of law whether or not you have to have a license before or after the marriage ceremony takes place. You are going to decide that de novo. The case that you have to look for is Shelton. It's uncontested in my case that my client was told by her husband that everything had been taken care of concerning the license when she asked about it at the house.
That was her testimony?
That's her testimony.
Is there a finding anywhere in the judgment or in the record where the trial court found that they both knew about the license requirement before the ceremony and attempted to skirt the statute?
The judge says...
Is there a finding, is there anywhere about...
He uses the word skirt.
Yeah.
He says that they attempted to skirt it. He also, but then he finds also that they both thought they were married. The requirement is good faith, because Shelton goes into the statute that abolishes common law marriages, and that's where you have the provisions in there that says that you have to have good faith on the person, on the part of the person asserting the marriage, not on both parties, but on the part of the person asserting the marriage. That's that statute's is 741-211. You have to have good faith and substantial compliance with Chapter 741. So in that case, you have the court reaches into that, though there's not a vestige of any more legal authority in that clerk to give them binding legal advice than there is in her husband. Now,
well, there's kind of a state action aspect to that, isn't there? Here's an official who is in charge of issuing licenses who's telling them it's okay to wait till Monday to file the license. That's a little different than husband saying, I've taken care of it. And incidentally, I don't think Judge Leroux actually ever made a specific finding that they believed they were married. He says, while both the petitioner and respondent may have believed they were married when they left the house, it is the finding that neither of them substantially complied with Chapter 741, suggesting, I think, not that there was a finding that they believed they were legal, but only saying that even if they thought so, they were still not substantial compliance. At least that's the way I read that judgment.
okay, well, Your Honor, I do ask you read, because Judge Leroux, throughout his style of writing on those, tends to soften the way that he puts the words in there. I would suggest to you that is a finding.
Mr. Townsend, why didn't the wife here use the curative provisions of Section 741.10 by having the witnesses confirm the license?
Because all the witnesses were under the control of the husband, who had already dumped her. The only witnesses, and again, this is not contested and is before you in the record of her testimony that is before you. She didn't know they were getting married at the River House when they drove there. She thought they were going there to pack up the car. He said, let's get married. He has his son, who's found not to be credible, the notary, who's a solemnizer. He has his, the Jason Gullett's sister, who is totally dependent. Well, I won't say that, but that's not before you in the record, but she is employed by him and works for him. And he has the daughter who gave them the card congratulating them on their marriage that morning, which is before the court. The issue that you have here is as a matter of law, is there good faith compliance, not as a, I'm sorry, is there good faith compliance as a matter of law, not in the technical issue of law, but in the belief by the party who is asserting the marriage? We have findings before you. She gave up every right she had under previous marriage. She had a 20-year marriage. She gave up. The judge finds that. She gave up every right that she had under that. She finds that Jason Gullett paid for her divorce.
There's some child support or something.
I'm sorry, sir?
There's some child support or something that she got.
I don't think there was, Your Honor. I believe she gave,
I thought I saw an affidavit in the record, a financial affidavit in the record that she put in that she suggested that there's it's not right. Don't worry.
Okay. The lawyer, well, I'm not going to go beyond the record that we have. I've taken this strategy of trying to bring, since we had such a complete record of the points here, so that I'm going to avoid the temptation of trying to go in and say all the things that went into this case. I do suggest to the court that we have someone here who is utterly unsophisticated, who is not overly intelligent, who is not someone who reads words. Throughout her testimony, she had confusion when she was asked words, and she would straighten them out when you say, well, what does that mean? And she couldn't say what the word meant, and then she would have to go back and straighten it out again. We had here a classic case of she would not sleep with him until she was married. It was something that was deeply part of her church beliefs, deeply part of what she felt was important, and we have a case where you have the strangest issues, obviously, once it's over, because we have less than a week later that he's sending her back to Palatka from Salt Lake City and having his wife meet him at the same time out there, his ex-wife, the one he's just divorced, and that he said he wanted to get married on the same day, and that Judge Nichols' legal assistant had testified that he had been continually pestering and trying to get to put a murder trial on hold so he could get this divorce over with, so he could have so that he could go through with the marriage. That he wanted to do it on the same day. And we have the case of where they go in within 2 hours, and we have it documented by the time they go in with get the ring from the safe deposit box, the sign-in time that we have on that. We have at the most 2 hours between the time that they went through the marriage and ceremony. Thank you. I'll just put, well, I'll
You may begin, sir.
If it please the court. My name is Preston Fields, and I represent the appellee, Jason Gullett. I have briefed this case to the best of my ability. I'm going to try not to repeat my briefs, but...
Let me stop you, Mr. Fields.
Okay, Judge.
Section 74108 says that before a marriage is solemnized, there must be a license pursuant to 74101.
Yes, sir.
Right. It doesn't say that the marriage isn't lawful.
That's correct.
It just says it has to be solemnized.
That's correct.
What are the consequences, then, of a failure of solemnization? Why would the failure of solemnization cause the marriage to not exist?
In responding to that, Your Honor, I think it's probably in looking at the entire chapter. That was one of the elements, that's one of the factors that the court must look at in determining whether or not there's been complete compliance with Chapter 741. If they fail to go through solemnization, the Florida legislature has instituted a provision, 741.211, kind of like a catch-all, to see if there's been good faith and substantial compliance. It gives the lower court the opportunity to kind of weigh the factors and see. But my position would be, that's one of the requirements that says you need to do this. And the other statutory provision...
Well, isn't the key, would you agree that the key is whether there's been substantial compliance? It doesn't have to be exact compliance.
Absolutely, that's the law. I agree.
And so the only distinguishing feature I can see is that there was some finding by the trial court that they intentionally attempted to skirt the provisions of the statute. But otherwise, in this particular case, you have a situation where, correct me if any of these facts are wrong, where the husband retains an attorney to get the wife's divorce in a hurry. He gets his divorce in a hurry with the intention that they're going to get married.
Yes, sir.
After the divorces are finalized, they have a ceremony, and 2 hours later go down and get their marriage license. And how isn't that substantial compliance?
Sure, I'll stop you and correct one thing from our position.
All right.
The court found that they went through some type of a marriage ceremony.
There was a ceremony.
There was some type of one. I will not admit there was marriage.
Trial court made a finding that the trial court made a finding that the parties thought they were married. So it must have been a ceremony that would lead the both of them to believe that they were married, right?
According to the trial court.
Okay. So, if that's not substantial compliance, then what is?
Judge, that's not substantial compliance for this main reason. One of the elements, if you look at the point number 2 in the appellant's brief, and I've responded to it, and if you believe the appellant, when the appellee says we're going to get married at the River House, the appellant says, what about my ring? What about the marriage license? And there was a great deal of inquiry at trial where she admitted that she asked that question. Why would a person ask, what about a license, if she didn't know a license was necessary? Number one. And number two, at that particular point in time, there was no application that even had been applied, no marriage license had even been applied for at that time. The only case, other than there's one estate case, I think it was Litsky, that kind of addressed Chapter 741.22 or 211, but Shelton is the primary case. And in Shelton, they'd already made application, they were getting ready for the wedding, they had everything set up. But in this case, they'd not even applied for the actual the marriage license. When they went in afterwards, they made the application. They didn't tell the clerk they just got married.
Well, what's the end result if we take a look at the statutes? Let me see if I can find it real quickly. Marriage license application valid for 60 days, and penalty for violation of 74103 and 74104. It says that the solemnization ceremony or solemnization shall take place, but what is the end result if it doesn't? I guess getting back to Judge Monaco's question, isn't the end result penalties for the person that issues the marriage certificate without the license, or as opposed to saying that the marriage is invalid or illegal?
I don't think it's illegal. If it doesn't comply, then they don't have a marriage. They've got to come in and establish a marriage and establish that they've substantially complied with Chapter 741. While there may be potential ramifications to the solemnizer, the net effect is that these two have not formed the institution of marriage, and that's what the ultimate conclusion is. And if you look at 741.0405.2,
what's the purpose of the substantial requirement as opposed to exact requirement? Yeah.
Well, under the way the case law has come out in the state of Florida, as in most states, it's the statute's more directory. This is what you should do, and the legislature does not appear to want to invalidate marriages if there's a small technical problem, if there's a small technical defect. Although the appellant attempts to make this a small technical defect, it gives the court the ability to look at the two witnesses and all the other witnesses. And again, I disagree with my opposing counsel. There's only part of a transcript here. You don't see anything else. No other part of the transcript. And under Applegate, you don't. In my brief, you have there's not a sufficient record for you to even reverse. However, I've already briefed that point. I want to answer your question. In this case, the legislature said if you've done almost everything you can do, and there's a small technical difficulty or problem, and you've given in good faith and substantial compliance, you complied with the chapter, we're going to say you've got a marriage.
And here, the only difference is that they held the ceremony before they went and applied for the license.
No, wait, that's one of them. And then the other part.
They went off on their honeymoon. I mean, they thought they were married, and for whatever reason, he ends up hooking up with or getting connected with his ex-wife that he just divorced, and leaving her and sending her back, and then coming back with his ex-wife. I mean,
Absolutely, Judge. One thing I will agree with Mr. Townsend.
I mean, it's certainly
this is a
bizarre.
strange set of facts.
Let me ask you something about what happened at the marriage license place.
Yes, sir.
Now, apparently the couple had already gone through, prior to the solemnization, they'd already gone through the marriage course so they could have an immediate marriage, right?
Yes, sir.
That was before the solemnization.
Yes, sir.
Then they had the solemnization. Then they went down to the courthouse. And what happened there?
They go in, they make the application, they fill out the application. You should have a copy of it as exhibit.
Both of them signed it.
Both of them go in and sign. She signs under the name of CATES, not GULLETT. If she's been married, she
Yes,
gets.
I understand.
And then they pay for the application.
Right.
The license is issued. At that point, the license is given. There's dispute as to whether or not there's signatures by the clerk at that point. But then the license is removed, taken apparently according to the trial court.
Why wouldn't the clerk have signed it then?
Judge, unfortunately, this is one of those cases where the normalities don't seem to apply, although I would think that a clerk would sign.
Yeah, I mean, unless it's the first time the clerk ever issued a license, I would guess.
Judge, this is one of those cases where...
All right, so anyway, who gets the license now?
I don't know if it was Mr. GULLETT or Miss CATES. One of the two receive it. They leave there, walk across the street to Mr. GULLETT's, to the place, the GULLETT title, that's where he was employed, and from there they leave. There's some testimony,
Who got the license? I mean, was it ever given to the solemnizer?
There was no finding of that. There's no,
And did the witnesses ever sign it?
according to Judge LaRue, he believes they did, even though they denied it at trial.
Is there a finding that the
There's a finding that the
witnesses signed it?
Yes, sir.
Okay. Is there substantial competent evidence? Oh, we can't tell from, we don't have the record.
What, Judge, there's no record, but quite frankly,
There was a finding.
there was a finding, but they testified they did not. There was no one. Well,
Okay. Well, but there was a finding that
Yes,
they
sir.
signed it. Was there a finding that the solemnizer
No,
signed
sir.
it? Okay.
and it was never returned back to the clerk. Now, again, you asked a question a minute ago, why didn't the appellant apply for the procedure, the curative procedure?
Right.
And that was part of our argument at trial. There was no evidence whatsoever of even an attempt to do that.
But his response was that to do that would have been fruitless, pointless, because the witnesses that would have been required for that were the husband's son or related to or friends of the husband.
That's
so
correct.
I mean, they weren't going to say anything contrary to the husband's position, were they? That's his argument. Respond to that.
I understand that, Judge. That's how it came out at trial, exactly that way. They testified they did not.
Because it would have been pointless.
It may have been pointless, Judge, but if you don't substantially comply. For example, in this case, where there was no.
What does substantial compliance mean to you?
Dadgum almost everything you're supposed to do. And then if you look at Shelton, they did everything they're supposed to do. The only reason they violated the 3-day wait period, they waited 2 of the days. And if you'll notice, on the 3rd day, the notary signed and the 2 witnesses signed. They did everything they were supposed to, except for that 3rd day. I'm sorry, Judge. And in Shelton, the only reason they sought later, at least a month later, to undo it was because the former, the new wife was going to lose some type of financial benefit from Metropolitan-Dade County, either workers' compensation or some type of benefits from her deceased husband. That's the only reason. So if you look at the only case in Florida that's interpreted this provision, there was only one small point that they didn't fulfill, and that was they waited 2 of the 3 days. That was it. They made application. They were given the license. They were told that they can proceed. The clerk even calls the notary and says, yes, you can proceed. And they told them to go forward. They had the big wedding. The next business day they come into the clerk's office. They sign everything. They did.
There are two parts to this. One is substantial compliance, the other is good faith.
Absolutely.
Did Judge LaRue make a finding of good faith?
I don't believe he did.
Well, he said that he thinks they may have, he thinks they believe they were married.
He thinks that he thinks that they think that they were married. But from my position, in order to show that you believe in good faith that you're married, listen, I can think I'm married to some type of a supermodel if I go through some type of
I think about that all the time.
Yeah. Although I am, my wife is a supermodel, and I want that dictated. The fact remains that you've got to go through and present it in good faith. And what we presented at trial and the exhibits that we presented at trial shows even after this alleged ceremony, she goes through and she uses the name of CATES throughout the procedures. And quite frankly, in the brief...
She couldn't go in and sign her name as...
Not after she knew what happened.
Yeah, I mean, she wouldn't have... I mean, doesn't common sense tell you that that's the name she's going to use to sign an application for a marriage certificate?
Tells me that, Judge, but
Yeah.
and there are other issues or other documents in the trial that she did use GULLETT. She was using GULLETT at a later point in time. She was using CATES at an earlier point in time.
When she goes in to get the license,
I'm sorry?
when she goes in to get the license, it
Yes.
isn't silly for her to use the married name.
I disagree.
That would
No,
make
sir.
sense.
I disagree, because if her claim is, we just got married, she would have been elated and say, hey, we just got married. The testimony that you don't have before you that's in the transcript was that, hey, if the clerk had heard that, they would say, no.
Well, isn't that what happened when they went across the street to where he works and he said, show off your wedding ring and, we're married and all of that?
That's allegedly what happened, according to her. I'm sorry, Judge. That's allegedly what happened after they went to the bank and to the orthodontist office. But coming back, the clerk of the court said, if they had said they had just gone through a marriage ceremony, they would have said, no. We can do it right here and right now. That's why Judge LaRue put that provision in the final judgment, because they could have gone through and corrected any deficiency. Any deficiency.
So Judge LaRue says the greater weight of the evidence shows the sister and daughter signed the license as witnesses.
Right. Although,
Not known whether a notary signed it.
although because you don't have the full transcript, there was no testimony whatsoever that they testified.
If we don't have a...
I know, Judge. I know. Okay. So in any respect, Judge, regarding whether or not there was good faith or not, it's our position, obviously, that she did not present it in good faith. Now, one of the other reasons why she did not present it in good faith is this is a divorce action. It was narrowed down to one issue, whether or not they were married. This was filed in 2005. In my brief, I refer to the civil theft of a marital right case, which was filed in 2003. Shortly after the alleged ceremony, a few months afterwards, the appellant files an action seeking to declare that we've committed some type of civil theft of a marital right. That case rocks on for 2 years. And in the complaint, they saw over $3 million worth of damages. They never saw the deck action in the lower court in that matter to declare whether or not they were truly married. Shortly before trial, they filed this action. The lower court stayed the civil theft action, and we proceeded. Now, if she truly thought she was married, why wasn't a deck action determined? Why wasn't this a divorce? And quite frankly, if this were a divorce action, if the appellee who just got divorced truly thought he got married, he knew how to go through a divorce, it would have been a lot cheaper for him to go through, file a petition for dissolution right then and there.
But still, you have to find that the trial court made he thought that they thought they were married.
I understand. So in summary, if I can go through my points real quickly, Mr. Townsend has argued that as a de novo review that the lower court made a rule as a matter of law, you have to have a marriage license before a marriage ceremony. That's not, respectfully, that's not correct. If you look at the trial transcript, the order on page A6 on the second paragraph, A5, the court says the above statute would clearly seem to indicate that the license must be issued prior to the time that the ceremony takes place in order for marriage to be legal and to be valid. However, at least one Florida court has stated that the parties need only be in substantial compliance with the statute in order to validate the marriage.
Well, there's a statute that says that too. It talks about there's no common law in marriage unless, unless there was substantial compliance.
Absolutely. What my
So
point is,
the legislature has put in the substantial compliance standard as well in Chapter 741.
absolutely. My point is that the court followed that. He didn't rule as a matter of law. He looked at it and said they did not substantially comply, more of a factual finding. If it's factual finding versus a legal finding, it's abuse of discretion. They have, obviously, this final judgment comes to this court with a presumption of correctness. It is their duty to bring forth a record which invalidates that or shows that that's in error. The fact that there is only a partial transcript in and of itself is an insufficient record. And I cited for the court the cases of Applegate, which is a Florida Supreme Court case. Just the fact that they bring only a very limited transcript is inappropriate for this court to have a complete record with which to even consider a reversal. And Judge LaRue heard 3.5 days of a very limited issue, wrote a just over 6-page opinion on, single-spaced on whether or not substantial compliance occurred. And there is competent substantial evidence out there to say that there was no substantial compliance. Your Honor, I could go through the rest of my brief. I know you've read it. Unless there's any further questions, I appreciate your time. Thank you.
Thank you.
So, Mr. Fields, if the issue is substantial compliance... Oh, I'm sorry. Mr. Townsend, if the issue is substantial compliance, and if that's a fact-laden issue, and if we don't have a full transcript, how can we move forward?
The issue is not a fact-laden issue, Your Honor. It's purely a matter of law.
Substantial
We
compliance.
brought substantial compliance with Chapter 741. It's whether or not you have before you, and we've cited the case from the 5th DCA, which I was that the findings of fact that the court gives you are the facts that you have to deal with in this case. I'm not going to go into there's a parallel case with this and all this. None of that's before you. This is a matter that's for you to decide. And those facts are as the lower court finds them. You have to take them as found and apply them and see whether or not those facts meet substantial compliance. We did bring up
What's the standard of review on the basis of whether those facts...
de novo.
How can it ever be de novo if you've got trial testimony?
Because
I don't understand how that could be de novo.
we have 3 issues that we brought before you. 2 of them are de novo. One is the evidentiary one. The question of whether or not the internal belief that he states in there, that when he says, and it only applies to my client because you're only applying that to whether or not this Chapter 741, that internal belief is a factual finding. It's irrelevant, though, because you're looking at whether or not, from the facts that the court below gives you, throw out. My challenge to is one fact there. Look at just the facts the court below gives you all the way through. You have to take those as true. Given those facts, is there substantial compliance with Chapter 741? And his legal finding, which you will be reviewing de novo, is that 741.08 requires that you have to have a license before you can get married. That's not what the language of the statute says. That's not what the case law in Shelton and Litsky says. And it's not what the case law that says substantial compliance goes. You're supposed to look at the whole chapter. You're supposed to see whether there's substantial compliance in it. There is no statement in the judge's findings.
Well, how about this? He finds They both testified they were aware of the requirement of a license before the ceremony. Are you doubting that?
Yes, I am. I do check. That's a factual challenge. That's the one I said that we made the challenge to.
It appears they simply sought to skirt that requirement. Is that a factual issue?
Oh, no, sir. Whether they sought to skirt that
I think it is, but that's
okay. But because 74108 does not require them to have a license beforehand. It requires the solemnizer to require a license. But there's nowhere in 741, in Chapter 741, that it
What happens to
says
the solemnizer if he violates the statute?
there are extremely poor penalties for notaries, and I have not
Are you
done...
saying that provision is put in there to punish the solemnizer rather than invalidate the marriage?
Yes, sir. And the reason I'm saying that is because the legislature full well knows how to invalidate a marriage when it wants to. There's two statutes in here that invalidate marriages, where you have, in 741, where you have same-sex marriages and where you have incestuous marriages. Both of those are invalid from the start. But there is nothing that applies to this kind of marriage that says it's invalid.
Thank you.
Thank you, counsel.
That's an interesting case.